Hello and welcome to Courts Today by LiveLaw. Let us get to today's top legal updates. A Delhi court has awarded life sentence to former Congress MP Sajjan Kumar in a murder case in the 1984 anti-Sikh riots. Supreme Court has quashed Bihar Legislative Council's decision to expel RJD MLC for comments against Nitish Kumar. The Supreme Court has urged union to negotiate with pharma companies to procure medicines for rare diseases at low cost. The apex court has directed Madhya Pradesh authorities to prove safety of Bhopal Gas Tragedy chemical waste disposal at Pithampur. The top court has today refused to entertain a PIL to protect Hindus in Bangladesh. Andhra Pradesh High Court has issued notice on a PIL alleging mismanagement in hockey Andhra Pradesh and sought clarity on association's recognition status. Election Commission of India has informed the Delhi High Court that it will decide Congress MP Randeep Surjewala's plea on Maharashtra and Haryana electoral polls within 3 months. And the Punjab and Haryana High Court has directed the NCB and CBI to conduct randomized raids to ensure prohibited drugs are not sold without prescription by chemists. I'm your host Urvashi Chauhan with your daily roundup of legal updates from across the country. For detailed reading, you can visit our website at www.livelaw.in. Make sure to watch this video till the end and please do not forget to like, share and subscribe to our channel. In a major verdict, a Delhi court has sentenced former Congress MP Sajjan Kumar to life imprisonment for his role in the 1984 anti-Sikh riots. The sentencing was pronounced by Special Judge Kaveri Baveja of Rouse Avenue Courts following Kumar's conviction on 12th February for the murder of a man and his son in West Delhi during the riots. This is the second conviction for Kumar in connection with the 1984 riots. The complaint in this case was filed by a woman who alleged that on 1st November 1984, a violent mob attacked her house, leading to the murder of her husband and son. She herself sustained injuries and their property was looted and set on fire. The complainant later came across a magazine featuring Sajjan Kumar's photograph and identified him as one of the people instigating the mob. After years of inaction, the Ministry of Home Affairs in the year 2015 constituted a special investigation team to reinvestigate cases related to the 1984 riots. During further probe, it was revealed that Kumar was not only present at the scene but was actively leading the mob, which was armed with iron rods and lathis, looting and setting homes on fire. The court had framed charges against Kumar in 2021 under multiple sections of the Indian Penal Code, including for murder, rioting, dacoity, attempt to murder and destruction of property. While delivering the judgment, the court noted that there was sufficient evidence to establish Kumar's role as a leader of the mob responsible for instigating and participating in the targeted attack. However, charges related to attempt to murder and destruction of evidence were dropped. In another important update, the Supreme Court today set aside the decision of Bihar Legislative Council to expel RJD MLC Sunil Kumar Singh for making defamatory words against Bihar Chief Minister Nitish Kumar. The case here revolves around Singh's use of the word Palturam for Bihar Chief Minister and imitating him, which led to his permanent expulsion from the Legislative Council. This alleged incident occurred during the budget session in February 2024. His expulsion was based on the Ethics Committee's recommendation, which reviewed the matter and found his conduct inappropriate. Singh filed a writ petition before the Supreme Court seeking to quash the report as illegal and unconstitutional. He argued that another MLC also used the same term but was only suspended for 2 days, making his punishment excessive. He claimed a violation of natural justice, stating that he was not given a chance to speak in the House before expulsion and was not shown the video evidence of his alleged misconduct. Citing the Raja Rampal case of 2007, he argued that parliamentary actions are subject to judicial review. Singh also questioned the fairness of the inquiry. He pointed out that the committee's report dated 14th June was submitted just 2 days after he was told that proceedings were still at a preliminary stage. Additionally, only 4 out of 7 committee members signed the report, raising concerns of bias. The council, on the other hand, argued that Singh had a history of misconduct and had been suspended earlier as well. It contended that he missed the committee meetings where he could have access to the video evidence against him. Also relying on the Raja Rampal case, the council maintained that courts have limited scope to review parliamentary decisions, particularly regarding disciplinary actions. Today, a bench of Justices Suryakant and N. Koteshwar Singh of the Supreme Court set aside the decision of the Bihar Legislative Council. The court agreed that Singh's behavior was abhorrent and unbecoming, but found his expulsion too harsh. It ruled that the punishment violated both his rights and those of the people who elected him. Since Singh had already been out of the council for 7 months, the court decided to treat it as a suspension, calling it a fair punishment. However, the court made it clear that this did not mean that his actions were acceptable. The court also stated that legislative decisions can be reviewed by courts. While Article 212 protects legislative proceedings from court interference, it does not apply to legislative decisions. It further held that ethics committee decisions are not part of legislative work, so they can be challenged in the court. Life-saving medicines for rare diseases often come with an unbearable price tag, making access a major challenge for patients and their families. Unlike common diseases, rare conditions affect only a small percentage of people. Pharmaceutical companies have to invest huge amounts in research and development, and they recover costs through high pricing. Many of these treatments are classified as orphan drugs, meaning they are custom-made and have a limited demand. Without mass production or government intervention, these medicines remain out of reach for most patients. In India, lack of a concrete policy for funding rare diseases treatments has sparkled multiple legal battles. The latest case involves a spinal muscular atrophy or SMA, a rare genetic disorder where a single dose of treatment can cost several lakhs or even crores. The Supreme Court has put a hold on the Kerala High Court's order directing the union government to procure medicines worth 18 lakh for a patient suffering from SMA. The court has also asked the union to explore options for subsidizing the cost of these life-saving drugs. The case originated from a 24-year-old SMA patient's plea in the Kerala High Court challenging the high cost of risdiplam, a crucial medicine for the disease. A single bench had earlier ordered the union to procure the medicine, but the division bench later clarified that this would not set a binding precedent for other similar cases. A Supreme Court bench led by CJI Sanjeev Khanna and Justice Sajjan Kumar was hearing the union government's appeal against the Kerala High Court order. The apex court has issued a notice and stayed the Kerala High Court ruling. The court has emphasized the need for international negotiations to bring down drug prices, pointing out that Pakistan and China have successfully done so. The CJI also urged the government and petitioners to explore direct talks with the drug manufacturers. The CJI stressed that with 900 patients suffering from such rare diseases in India, the government must step in to negotiate better pricing. However, the union government has clarified that these medicines are custom made for each patient on a monthly or biannual basis, making mass procurement difficult. Let me tell you, the Supreme Court is currently handling multiple petitions filed by parents of children suffering from muscular dystrophy, another rare disease seeking free treatment policies. Also, in a related matter, let me tell you, in December, the top court had stayed the Delhi High Court's decision to remove a 50 lakh cap on rare disease treatment funding. This matter will now be taken up on 17th April. Stay tuned. In another update, the top court has stepped in on concerns surrounding disposal of Bhopal Gas Tragedy chemical waste at Pithampur, Madhya Pradesh. The court has asked the state authorities to present material proving that there is no risk to nearby residents. Well, this case stems from a 2004 PIL highlighting the failure of clear toxic waste still lying at the Union Carbide factory site even 40 years after the 1984 Bhopal gas tragedy. In December last year, the Madhya Pradesh High Court criticized the prolonged inaction and ordered an immediate cleanup. However, concerns were raised about disposal to the Pithampur facility because of its proximity to human settlements and a nearby river, with claims that no advisory was issued before the decision to transport and dispose the waste. Today, the matter was mentioned before a Supreme Court bench led by Justices B.R. Gawai and A.G. Masi, which is hearing a plea against the MP High Court's order that directed transportation and disposal of the 337 metric tons of hazardous waste from the Union Carbide factory site to Pithampur. The petitioner here fears that disposal of this toxic waste could harm residents and the nearby river. Well, the court has now put the onus on the state authorities to show that adequate precautions have been taken. The High Court had earlier ordered a trial run of 10 metric tons of waste starting 27th February. The Supreme Court, however, has now said that it will hear the matter on 27th Feb and expects the state to present concrete proof of safety measures before proceeding. Justice Gavai warned that if proper safeguards were not ensured, the trial run should not become a fait accompli. The matter will now be taken up on 27th February. Stay tuned. In recent months, Bangladesh's minority communities have faced escalating challenges. Following the student-led uprising in August last year that ousted Prime Minister Sheikh Hasina, reports indicate a surge in violence against religious and ethnic minorities, including killings, rapes, and property destruction. The interim government, led by Nobel laureate Muhammad Yunus, has been accused of failing to protect these communities. The government, though, disputes these claims, attributing the incidents to political rather than communal motive. In this regard, a PIL was filed in the Supreme Court seeking protection of Hindus in Bangladesh from violence targeted at minority communities. It was filed by Rajesh Dhanda, the chairman of Bhagwan Jagannath Rath Yatra Mahotsav Committee, Ludhiana, who is also the vice chairman of ISKCON Mandir Steering Board. But the bench of CJI Sanjeev Khanna and Justice Sajjan Kumar declined to entertain it. The bench at the outset refused to interfere in the issues of foreign affairs and internal developments of the neighboring country. Further, on the advice of the bench, senior advocate Mukul Rohtagi, appearing for the petitioner, withdrew the PIL. Moving ahead, the Andhra Pradesh High Court has issued a notice on a PIL alleging financial fraud and mismanagement in the Administrative Committee of Hockey Andhra Pradesh, a federation affiliated with Amateur Kabaddi Federation of India. The court has sought a response from the Sports Authority of Andhra Pradesh and Sports Authority of India on the status of federation's recognition and its impact on the players participating in its events. The division bench of Justice Dheeraj Singh Thakur and Ravi Chimalapati issued the notice questioning how players can participate in events organized by Hockey Andhra Pradesh, even though it has not been formally recognized. The court has asked the Sports Authority of Andhra Pradesh to clarify its stance on this issue. The court noted that Hockey Andhra Pradesh was placed under a 3-year observation period as per a communication dated September 2023. This period is set to end in August 2026, after which the association may receive recognition only if it complies with the National Sports Development Code of 2011. The petitioner in this case has alleged serious financial irregularities within the federation and pointed out that multiple cases related to its administration and recognition are already pending. A representation was submitted to the Sports Authority of Andhra Pradesh in November 2024, but the authorities have not responded yet. The plea also raised concerns about the uncertain future of hockey players who are participating in events organized by Hockey Andhra Pradesh. Without formal recognition from the Sports Authority of Andhra Pradesh, their achievements may not be considered for sports reservations in education and employment. Finding merit in these concerns, the court has asked the sports authorities to respond and directed the Sports Authority of Andhra Pradesh to consider the petitioner's representation and issue a speaking order within 8 weeks. The matter is now listed for hearing on 16th April. The Delhi High Court has disposed of a petition filed by Congress MP Randeep Singh Surjewala, in which he sought a direction to Election Commission of India to decide on his request for electoral rolls from 2009 to 2024 Lok Sabha and Vidhan Sabha elections in Maharashtra and Haryana. Appearing for Surjewala, senior advocate Abhishek Manu Singhvi pointed out that while ECI had assured that a reasoned order would be passed, it did not specify a clear deadline. He pointed out that ECI took 2 months just to acknowledge Surjewala's request and say that a decision would be made later. However, instead of giving a definite timeline, ECI only indicated that it needed more time. Singhvi criticized this delay, saying that if such an approach continued, there would be no certainty on when the issue would actually be resolved. ECI's counsel, however, argued that since electoral rolls from 2009 onwards were being sought, retrieving and verifying such extensive data would take time. The court was informed that 3 months would be needed to make a final decision on the matter. Without going into the merits of the case, Justice Jyoti Singh accepted ECI's commitment and disposed of the plea, directing that the decision be made within 3 months. The court also granted Surjewala liberty to take further legal action if needed. And lastly, the Punjab and Haryana High Court has directed the CBI and Narcotics Control Bureau to conduct random raids at medical stores and chemists suspected of selling prohibited drugs without valid prescriptions. A bench comprising Justice Deepak Sibbal and Justice Harpreet Kaur Jeevan emphasized that strict measures must be taken to prevent the illegal sale of such drugs, which are often covered up with fake or duplicate prescriptions. The direction came after the CBI submitted an interim status report revealing that several chemists were illegally selling drugs that require a doctor's prescription. The court has ordered CBI and NCB to submit a report on the steps taken by 4th March. Also, the court refused to recall its 2021 order by which it has transferred an investigation from Punjab Police to the CBI. The case involved the recovery of tramadol hydrochloride, a narcotic drug under the NDPS Act, which was allegedly not being fully accounted for by the state authorities. The court had earlier noted that some of the recovered drugs were reportedly being used to falsely implicate innocent persons. The Punjab government sought to modify the order, arguing that it lowered the morale of state police. However, the court observed that the order was never challenged earlier and had already led to a CBI investigation, and charge sheet had also been filed. The court also pointed out that no legal provision under Bharatiya Nagrik Suraksha Sanhita was cited to justify recalling the order. Significantly, the court highlighted that drug trafficking is a regional issue affecting Punjab, Haryana and Himachal Pradesh, and that an investigation by a central agency like CBI or NCB was necessary.